Hello and welcome to the 12 CP Barristers talk on charging decisions, use of the Fraud Act and use of consumer protection from unfair trading regulations. I'm Edward Elton, this is Amber Athill, and we're both general crime and regulatory crime barristers at 12 CP in Southampton.
This talk will be in two parts. The first will deal with the Fraud Act and the consumer protection regulations, and the second part, my part, will cover briefly the Companies Act, the Theft Act and the Proceeds of Crime Act.
Diving straight in then, what are the main offences under the Fraud Act 2006? They're set out in Section 1 of the Act. A person's guilty of fraud if his actions amount to fraud by false representation, and that's in Section 2. Fraud by failing to disclose information, and that's under Section 3. Or fraud by an abuse of position, under Section 4. Taking those one by one, a false representation might be, for instance, that £28,000 worth of roofing work is required when it isn't required and the roof is perfectly fine. It might be, under Section 3, a failure to disclose information might be that, well, I have no training as a gas fitter, but I'll have a go at putting a new boiler in. I just won't tell you that it's highly likely to be incredibly dangerous. And an abusive position would involve, for instance, a carer who might use their position being in charge of an elderly person's finances to perpetrate a fraud. There are other offences under Sections 6 and 7, for instance. There are offences of possessing, making or supplying articles for the use in a fraud. And under Section 9, there is the offence of participating in a fraudulent business other than a company. And I know that Amber later on will be talking to you about the position when it does come to limited companies, but if, for instance, you're the employee of somebody and you're up to no good and the company's up to no good and it's systematically working in a fraudulent way over time, then the correct charge might be under Section 9, participating in a fraudulent business. Turning to the consumer protection offences under the regulations 2008, as you all probably already know, they're set out in regulations 3 to 7. And in short, a commercial practice is unfair if it contravenes the requirements of professional diligence and materially distorts or is likely to materially distort the economic behaviour of the average consumer. It's a misleading action under the provisions of Regulation 5, and an example of that might be somebody saying, oh, yeah, these are definitely genuine parts, when of course they're not. Or it might be, this is a fair price for the work I'm doing to mend your chimney or to carry out the tree pruning in your back garden, when it's not a fair price. A misleading action under Regulation 6 would include, misleading omission, forgive me, would include not giving cancellation rights when going door to door selling your services. Or it might be more fundamental than that, the omission to say, well, look, these tiles that I'm putting on your roof, £12,000, they're not waterproof and they won't stop the rain getting in. An aggressive action would be, for instance, taking the consumer to the bank for them to get money out to pay you for the goods or services that you're supplying, or making midnight phone calls and sending dozens of text messages chasing payment. But again, for each of these, I'm sure each of you will have plenty of examples from real life of things that clearly fall into one or other of those categories. And there is, of course, Schedule 1, which sets out a list of things that is an unfair commercial practice, code of conduct matters, quality mark matters, endorsements and the like. I once prosecuted some dog trainers who claimed to have successfully trained dogs for Bruce Forsyth, Bobby Davro, and of course, in that trilogy, Liam Gallagher from Oasis. It wasn't true, and it was therefore an offence under Schedule 1. Other less show-busy ones would include, of course, claiming kite marks when you don't have the kite mark, or claiming your checker trade approved when you're not, or at least when you're not any longer. Now, one thing that can cause angst is deciding, should I be charging Fraud Act charges here, or should I be charging consumer protection regulations charges? And the short answer to that is that usually there is no entirely correct answer, but there will be signposts that will point you in the direction of one or the other, depending on the particular bit of activity of an offender that you want to deal with that particular charge. Using the regulations first, it's important to note that dishonesty is not a required element of any of the consumer protection offences. And obviously, the fewer things you have to prove, the easier it is to get your convictions. Now, the consumer protection regulations are perfectly designed for use by trading standards officers. They can often feel like a warm security blanket for TSOs, who then sometimes don't look beyond them because it's what they're used to, it's what they were trained on, it's what they've got templates for already. But it does only have a maximum sentence for each offence of 2 years, and there is, of course, the time limit under Regulation 14 of 3 years from the commission of the offence, or 1 year on from the prosecutor becoming aware of the offence having been committed. And whilst, of course, it's important to note that the prosecutor will not be the same person as the investigator, there are those time limits for consumer protection regulation offences. And, of course, there is the statutory defence under Regulation 17 of due diligence. I did all that could reasonably be expected of me, will defeat any charge, no matter what evidence you might have to the contrary, so long as they're able to persuade a lay bench, a district judge or a jury that they had exercised all due diligence. And finally, of course, consumer protection regulations offences do not necessarily lead to pocket confiscation. And it's always a major aim for any investigation where money has been wrongfully obtained by offenders to try to return. And confiscation is a very good mechanism. Get a confiscation order for compensation for victims. It gets the money back sometimes a lot more quickly than a simple compensation order because of the time in default, about which Amber will be telling you later, that's attached to every single confiscation order. Turning to the Fraud Act offences, anytime there is a misrepresentation used to make a gain, it sounds very much like a fraud. But important to note that dishonesty is a necessary element of every Fraud Act charge. So if you can't prove dishonesty successfully, then the charge is going to fail. Fraud Act can sometimes cause a great deal of angst in the minds of trading standards officers because they feel somehow it's not for them. But it's really as simple as using a misrepresentation to make a gain and doing it dishonestly. And it's important always to consider using the Fraud Act because it does have a maximum sentence of 10 years as opposed to 2 years. And there's no time limit for bringing a prosecution, short of anything that would amount to an abuse of the court's process because it's been quite so long. So long as you have been actively investigating, if it takes 1 month, 1 year, or 5 years, it won't be a time bar to bringing Fraud Act charges. And Fraud Act offences, when proved, usually result in pocket confiscation, at the very least being a possibility, if not an actual outcome. And this is the one central message I would give to you all, is that you don't have to pick your legislation. You don't have to say, I'm just charging Fraud Act, or I'm just going to charge the regulations. You can mix and match. So you can charge the right offence for each set of facts, for each part of your investigation. And the most important message is, of course, just don't panic. If you're ever in any doubt and you're not quite sure which direction the signposts should be pointing you in, certainly we 12 CP barristers will always be delighted to advise you at a very early stage. It doesn't have to be anywhere near charging. We'll happily advise you, a nice long advice or a nice short advice, it's up to you. We will happily point you in the right direction if ever we can, and we'd much rather you contacted us early than you contact us too late. Now, when using Fraud Act and consumer protection regulations offences together, you can use them properly to cover the full width of all of the offending behaviour that you're investigating. For instance, when there is obvious dishonesty in some parts of it, you'll be leaning certainly towards the Fraud Act for those. But where it's simple rogue trading without necessarily dishonesty, then you'll be looking more quickly at the consumer protection regulations to cover those parts of the offending. But there always is with lawyers, but there's a caveat to that. If you're charging the Fraud Act offences and consumer protection regulations charges as alternatives based on the same facts, or even if you don't think they're alternatives, but they are based on the same facts, if the defendant was to enter guilty pleas to the consumer protection offences, you would not then be able to proceed with the Fraud Act matters to see if you couldn't do better than what they were offering. You would be stuck with what they'd pleaded to. Also, I did say earlier, you can use a mixture of both sets of regulations and offences under the Act to cover the full width of offending, but it's important to remember that no judge ever said, thank you very much for this 78-count indictment. I can't wait for my clerk to read this out to the jury. So just because you can charge does not mean that you should charge. As a golden rule, if you concentrate on the main transgressions and charge those, whether they are Fraud Act matters or whether they're consumer protection matters, you can then use all of the rest of things that you could have charged. That evidence doesn't go to waste. You can use that to show the truth of what you say about the main matters. If you had a Fraud Act charge because the work was wholly unnecessary and it was a misleading action to say that it was necessary, but also they hadn't given cancellation rights, you are entitled to adduce that information so the jury understands that should have allowed a cooling off period and didn't do so, should have told them they could cancel and didn't do so. Why would they do that, members of the jury? Because they wanted to get on, do their shoddy job and get their ridiculously large amount of money and get out before the poor old householder had time to think, hang on, something's wrong. So the evidence doesn't go to waste, but you don't have to charge everything just because you could charge it. Now, to turn briefly to a scenario to illustrate what I was saying, if you have a cold calling roofer who claims to be checker trade certified, but isn't, who gives no cancellation right information, carries a bucket of water up into the roof space and carefully tips it between two rafters before going downstairs and saying to the aged and vulnerable consumer, oh, look at the terrible damp you've got. That's coming in through the roof, that is. Your whole house will crumble to dust if you don't get this fixed. It'll only cost you £28,000. I can start, tomorrow. And then stands very close to her while suggesting that she drive him off immediately to the bank to go and get out a deposit of £8,000 in cash before he starts to fix the problem with her roof, and then does a rubbish job that takes many more thousands to put right when finally it's discovered. What offences would you charge the defendant with? The answer, of course, is you could pretty much charge every offence under the regulations and the Fraud Act. But if you concentrated on the worst aspect, that would be the fraudulent aspect of his activity, and charged fraud by misrepresentation, you could then use all of the other evidence of all of his unlawful behaviour as evidence to support the central contention, which is that he went there to defraud her and defrauded her. And apart from anything else, no judge is going to aggregate the sentences. If you did charge all 17 offences, he's not going to say a year for that and a year for that and a year for that. It comes to a total of 17 years, take him down. It's not going to happen. If you did charge them all and you got away with it and the judge didn't give you too much of a hard time and the jury convicted, the judge would only pick the main one anyway and say, you're getting 2.5 years for the fraud, 3 years for fraud, whatever it might be, and no separate penalty for these, or a year concurrent, or whatever it might be. So it's not going to make the sentence any worse. And because you've got the Fraud Act matter, you're probably going to be looking to turn to POCR anyway, about which Amber will tell you when she gets to it in her part of the talk, which starts now.
Moving on then to the Companies Act 2006 and considering specifically Section 993, which is the offence of fraudulent trading. As Edward has already said, you also have Section 9 of the Fraud Act, which focuses on sole traders. Here we have Section 993 for companies, so to include limited companies. Section 993 reads, if any business of a company is carried on with intent to defraud creditors of the company or creditors of any other person or for any fraudulent purpose, every person who is knowingly a party to the carrying on of the business in that manner commits an offence. So the important question there then is the company being carried out for fraudulent purpose? And do the directors know this? Was the company created? Was it set up for the purpose of defrauding its customers? Does the company regularly and systematically defraud its customers? There may, for instance, be individual instances of a dodgy car salesman punting out sales for a 2-year period, but only 2 or 3 offences occurring during that 2-year period. This may not be sufficient for a Section 993 offence. On the other hand, just because there are instances of genuine, honest work does not mean that Section 993 cannot be used. The question is this: is the general thrust that the company overcharges for poor services? Is the general thrust that they inform customers that works are required when they are not? Is the company being carried out for a fraudulent purpose? Of note, Section 993 is particularly good if you're trying to charge a director who does not attend each and every job. He's not the person to do the manual labour, he's not necessarily the person giving the customer the quote. But he will still be liable under Section 993 if he knew the company was being carried out for a fraudulent purpose. Of course, you can charge a Section 993 offence on an indictment that also contains counts of fraud or counts of consumer protection regulations. Moving on then to very briefly consider the Theft Act 1968. Now, it is important to note that just because you are trading standards does not mean that you have to limit your prosecutions to the Fraud Act or to the consumer protection regulations. Usually, of course, the Fraud Act, the Consumer Protection Act and the Companies Act cover the extent of the offending, but they do not always. Sometimes there will be facts that do not fit into these offences. Can you instead charge under the Theft Act 1968? Are there instances of theft, robbery, burglary, false accounting? Of course, if a company is fraudulent, it is likely that the accounts are not legit. If there is clear evidence that a defendant is falsifying documents or using misleading documents for the purposes of accounting, consider charging him or her with false accounting. Is there also instances of handling stolen goods, going equipped? Consider charging under the Theft Act 1968. And as Edward has pointed out already, if you need any further advice, we are of course always open to advise on such matters. Moving on then to the Proceeds of Crime Act 2002. Now, the important thing here is to get your financial investigator involved as soon as possible. Get a restraint order as soon as possible. If the defendant is the sort of person who will try to spend all of their money, then get a restraint order. This will ensure that there is money at the end of the trial for the all-important POCA proceedings. Also to consider is just because you can charge a defendant with a stand-alone POCA offence does not mean that you should. Of course, with fraud, if convicted or if the defendant pleads guilty, POCA will automatically come into play. You do not therefore have to charge the defendant with a separate POCA offence. You can, of course, but you must be prepared that the defendant might plead guilty to that POCA charge, and if it is based on the same facts as the fraud charge, you may not be able to proceed to trial with the fraud. So when is it a good time to charge a stand-alone offence of POCA? A good time is when the facts for the offences you have got do not include dealing with the money received. The POCA charge will then plug that gap in the offender's behaviour. By way of example, if you were to charge an offence of professional diligence, then the fact of money being paid is irrelevant to that charge. It would be appropriate then to consider a money laundering charge. POCA also tends to come in handy when a financial investigator notes money being transferred from the company account or the account of the trader to a third party, or when a complainant is asked to send money to the third party. And that third party is often, of course, the defendant's partner or a family member of the defendant. As I'm sure you're well aware, what then tends to happen is that partner, that family member, is asked to withdraw the money in cash. Is there a reasonable explanation as to the money going into that partner, that family member's account? If not, it may be appropriate to charge money laundering. But it does not mean that you should definitely charge a count of money laundering. One has to consider, of course, if it is in the public interest to prosecute. One has to consider whether the partner or the family member really knew or could have suspected what the main defendants were doing. Did they know how much the company was making? How it was that the company had that much money? Did they know, importantly, that the company was defrauding its customers? Did they attend the jobs with them? Did they know how much was being charged? If not, do they really have the requisite knowledge or suspicion? Is it reasonable to charge, for instance, a 90-year-old lady of good character who just thought she was doing her son a favour, thinking, of course, that her son was a good, hard-working, honest labourer? Is it reasonable to charge a naive 16-year-old boy who was just doing what his dad or his uncle or his brother asked of him? Was it a one-off, or is it a pattern occurring? Are they constantly receiving money from the defendant or the defendant's company? Were they receiving a benefit or any money for having this money go in and out of their account? The point is, of course, that each case is fact-dependent, and again, we are open to advise in relation to the POCA charges at any stage, but as Edward has said, as soon as possible is best. Moving on then to consider POCA after a trial. As I'm sure you're aware, POCA can only be dealt with in the Crown Court. If the case has been dealt with in the magistrates, it will be committed under Section 70 of the Proceeds of Crime Act of 2002. The Magistrates' Court has no jurisdiction to consider POCA confiscation. Once in the Crown Court, it involves assessment of the benefit figure and the available amount. The benefit figure for particular criminal conduct is how much the defendant received from committing the fraud or from handling stolen goods, whatever that criminal conduct is. The available amount is quite literally that. At the time of the hearing, how much has the defendant got in assets? How much can they pay? Of course, if there is a restraint order in place, there tends to be more money to confiscate at the end. There is, of course, also, as Edward mentioned, prison time in default, up to 10 years, depending on the amount of the confiscation order. Of note is that if they do not pay the money and they go to prison in default, even when they leave prison, they must still pay that money. They still owe the money. Likewise, if the defendant suddenly wins the lottery, the confiscation order can be varied and the available amount can be increased. And in some cases, the lifestyle provisions kick in, going back 6 years from the date of the charge. And there are, in relation to the lifestyle provisions, 4 assumptions under Section 10, and they are as follows. 1, any property transferred to him after the relevant day. 2, any property held by him after the relevant day. 3, any expenditure incurred by him after the relevant day and was obtained through his general criminal conduct. And 4, he obtained it free from any other interest. Finally then, some general comments in relation to POCA. The judge has no discretion in terms of the available amount or the benefit figure. The defendant cannot pull on his or her heartstrings. POCA is deliberately draconian, and the Court of Appeal have said as much. It is for us, essentially, to take the money off of these villains. And remember, everyone, be nice to your AFI, and they will help you disentangle the bad guys from their loose. Thank you.
Thank you, Amber. Now, normally at this point we would say, has anyone got any questions? But that's going to be awfully difficult to deal with. So if you did have any questions, please send them either to Amber or to me or to both of us, care of clerks@12cp.co.uk. Thank you for watching.
Thank you.